the one important facet of advocacy, and that is legal writing. What is legal writing? In fact, writing is one thing which we learn from childhood, from our schools. And yes, it depends on how much aware you are being met about various skill sets which are required for writing properly in your schools in childhood. But one thing is sure, that we all write from very beginning. And when it comes to legal writing is writing about law. So that is what legal writing is. And when it comes to legal writing, then one thing you must understand and realize, that legal writing is being done by people who study law, and thereafter they obtain law degree, and then they claim themselves to be professionals. So as professional, you must be aware of, and you must know the basics of legal writing. That is the list which is expected from every law student. Now, what is the purpose of legal writing? That is what is something very important. See, when we talk about practical experiences and the experiences which you should have in your law school, I would say that this legal writing, this legal drafting is something which everybody should start giving emphasis on from very first year of your law school. And you must take out time for making yourself aware of the basics of legal drafting, legal writing, and you should work as much as you can on legal drafting. That is something, in fact, legal drafting is your personality. Legal writing is, if you write something and it goes before, these days you have so much of option of writing, do legal writing. You can write blogs, you can write articles, and on various websites. So that is this is how you can train yourself. And when you write something, then you commit yourself through your writings, and it goes before the intended readers, and those intended readers would get to know about your knowledge of the subject on which you have written with that written in that particular blog or wherever. That is your personality, that is your individuality, that that reflects your wisdom, that reflects your knowledge. Now, therefore, legal writing is a serious business, and one should take it with all seriousness. Now, when we talk about legal writing, first and foremost thing is to know what is the purpose of legal writing. Purpose of legal writing is to accomplish a specific objectives. Now, when we talk about a specific objective, now suppose you have written a legal brief, you have written a pleading. Now, it is intended for court of law. It is intended for the judge concerned, before whom your matter will be placed. Now, if you have written a legal opinion, it is meant for your client. So you have written about your understanding of law in a particular situation. So it is intended for the for your client. So it has a specific objective. An objective, when it goes to the court, objective. So you have to understand what is the objective. You have to understand what is the objective behind that particular writing. Now, you want certain effect through your writing, through your legal writing. You want certain effect on the target audience, and that is why it is called that everybody who is writing something must know his audience or must know her audience, because your writing should depend on the audience. Your writing should depend on the need of the audience. Your writing should depend on the interest of the audience. In fact, your writing should depend on the background and the knowledge background and then the knowledge of the audience. If you are writing something for your colleague lawyer, you know he is a lawyer, he may be your senior, he may be your junior, you know he is a lawyer, you write in a particular manner. You may be using legal jargons and various statutes in a very short form, but if you are writing an opinion for your client, for you who would be a layman, then you cannot write the way you have written for your colleague. Now, so therefore, it is also important to know the background and the knowledge base of the person, the audience for your writing. Take the example of judges. As I said, that you must know the purpose of legal writing is to accomplish the specific objective which I said, and you must know the need and the interest of the intended audience. Now let us talk about the need of a judge before whom your pleading is going, your brief is going. What is the need? Need of the judge is to understand the relevant facts, understand the relevant laws from your pleading, which will help him in deciding your case. So that is the need of the judge. What is his need? He wants to have relevant information from your drafting so that he can decide his duty, that is to decide the case. Now, one must understand one thing, that judges, particularly I'm talking about judges in India, they are always hard pressed with time. I would say you should take it that judges will give not more than 90 seconds for a brief, particularly in Supreme Court judges when they are having hundreds of matters to be decided every day. They are always, in fact, forget about only Supreme Court, Indian Supreme Court, judges always will be lacking time. They will have limited attention span for your matter. Now, therefore, in a limited time which would be available to you as an author of a particular brief, you should convey your case to your audience, that is the judge concerned. Now, how to do it, how to write this, that is something which we will cover today. And let me straight away tell you what you should do and what I prefer doing and what I have been advocating for is, how so big or complex your case may be, you as a lawyer must know your case theory, and you must be in a position to write your summary and gist of your entire case in one paragraph. If you are able to summarize your case theory in one paragraph, it means you have understood your case. It means you have understood the relevant facts of your case. You have understood the relevant laws which are applicable in your case. And it means you have understood why you are right in what you right in saying what you are saying. If you can write your entire case in one paragraph, then it means you have mastered the art of legal writing. It is not that easy. It requires, it comes with experience. One has to work hard to master this art of writing your whole case in one paragraph. In fact, all of you who would have gone to Supreme Court to observe the hearings, particularly on SLP days, you would have seen that the case is called out and the lawyer concerned will get up, and in one or two sentences, he summarizes his whole case. And that 1, 2, 3 sentence, what he talks about, gives him either the relief which he wants for his client, or he gets the dismissal of the case. What is important for you to understand is, if a lawyer appearing in SLPs, especially petitions in Supreme Court, can summarize their whole case in couple of sentences, why can't you do it? And why can't everybody do it? And why can't you do it from your law school? And that is the challenge you have to take for yourself. Try to master this from your law school itself. And that comes obviously with some hard work. And in fact, I would say that the precis writing is a very interesting way of starting this kind of exercise, where you have a document running in few pages. You have that document before you, and you have to summarize that entire document in lesser words, lesser number of pages, and this is what you are doing. If you are doing it, then it means you have started preparing for this. How to prepare case theory? What is case theory? I'll cover it in a while. But 3 basics qualities of legal writing, what in my understanding, and there are a lot of other people who says that these are the 3 legal these 3 qualities for legal writing. First is clarity. Second is conciseness. And third is ability to engage the reader. Now, what is clarity? In fact, Ben Garner, who has written many books on various aspects of legal writing, he says, and I quote, "One feature of a good style trumps all others: literary elegance, erudition, sophistication of expression. These and all other qualities must be sacrificed if they detract from clarity." So clarity of your writing is of paramount importance, is very important, and this is what is being highlighted in this quote. So when we talk about clarity, we are talking about clarity of thought. We are talking about clarity of expression. We are talking about clarity of what we intended to write. Now, as I said in the beginning, every person, everybody who is writing something, who is doing some legal writing, must keep in mind the needs and interests of the audience and the reader, intended reader. And your document cannot serve its purpose if intended reader cannot make use of the document. And therefore, clarity is of paramount importance. Clarity depends on number of factors and is context dependent. Clarity requires knowing what needs to be said. So you must know what you want to write. You must know the facts, you must know the law, but avoid the verbal clutter. Be economical in your words. use ordinary language unless there is need for a special terms. Use words which are simpler from your vocabulary. In fact, I would say that good draftsman and good pleader always will have good vocabulary. But then how you use that vocabulary is very important. One of my friends I know is a practicing lawyer. He would remember almost all the words in English dictionary. But the way he uses them sometimes irritates the judges. If he's talking to you and you are sitting as a judge, now you don't want to test the English. It's not a test of your vocabulary. However, having good vocabulary is very important. It helps you in forming your thought process. If you have good vocabulary, you can shorten your sentences, but don't use uncommon words from your vocabulary. Be simple. Make your write plain English. In fact, it is a movement. There's a movement of plain English going on for a good number of years now. And proponents of this movement and the people who back this movement say that it has really, this movement has really brought good answers to the problem, because earlier the lawyers used to write complex words just in order to make themselves special and show to the world that they are special. They have different vocabulary and so on and so forth. But now even if you see the statutes in many developed jurisdictions, now the way it is written now is simple talkative English, simple plain English, not the way it used to be written earlier. Though in India we still have not learned from this plain English movement. We still have statutes which starts by saying notwithstanding anything contained anywhere in other act and so on and so forth. And then you have people struggling to while interpreting those provisions. So clarity of thought, as I said, use of proper words, use of ordinary language. Now, omit surplus words and glue words. I have two sentences and you will see the difference between these two sentences, and I'll read two sentences and then we will discuss the difference between these two sentences. Our first sentence goes like this: a trial by jury was requested by the defendant. So first sentence is, a trial by jury was requested by the defendant. Now let us understand how many working words you find in this sentence and how many glue words you find in this sentence. Glue words means the words which keep these working words together. A trial by jury was requested by the defendant. So working words are trial, jury, requested, and the defendant. And glue words are or, because it starts by saying our trial, by, another glue word, was, and by the. So a trial by jury was requested by the defendant. So you have in this sentence 5 glue words: a, by, was, by, and the. And how many working words you have? Trial, jury, requested, and defendant. So if you see the ratio, glue to working ratio, it is 5/4. Now let us have another sentence. And this sentence reads like this. The defendant requested a jury trial. The defendant requested a jury trial. So now let us count how many glue words and how many working words we have in this sentence. Here you have defendant requested jury trial. So these are 4. So working words remain the same, 4. But see the glue words. And glue words are only 2, the and a. So the defendant requested a jury trial. So glue to working word ratio is 2/4. In the earlier sentence, it was 5/4. So better writing is the sentence where you have lesser number of glue words. So this was one of the examples, one of the way to remember how to avoid surplus words, how to write in economical manner. Now, very important thing which we all must keep in mind is, apart from having good vocabulary, we must also have reasonably good knowledge of grammar and punctuation, proper writing skills. We must write small and simple sentences. Try to limit your sentences to 20 words. You should have a small paragraph. 1 paragraph, 1 topic. Avoid using too many negatives. Prefer writing in active voice. Give emphasis on and be about proper font and typeset. It should look presentable what you write. You cannot afford to have 2, 3, 4 different fonts in your document. It should be pleasing to the eye. It should not irritate the reader. And I will give, it should be talkative English. It should be simple. In fact, good draftsman, if you're writing for a court, you should be a good storyteller. And good storyteller is one who creates interest in the audience, who does not irritate the audience, who keeps the interest alive in the audience. Now, just because you know complex and you have got very big vocabulary does not mean that you should write words in such a manner that reader may have to consult dictionary. It is irritating, to say the least. Secondly, you must know legal language. You must know how lawyers write, how they should write. You must know how you write. Legal language. Now, I'll give you an example. During this COVID outbreak, from 16th of March till 2nd of April, I was doing one emergency arbitration under the rules of Japan Commercial Arbitration Center, Arbitration Association, JCAA. It was seated in, it was happening in Tokyo, though we conducted this whole entire proceeding through video conferencing and everything. It was a joint venture dispute. I was representing one joint venture partner, another side was being represented by a very big Japanese law firm, and that law and one English lawyer practicing in Japan was representing that client. They had very good case on facts in law as well. But the way, the kind of English that gentleman used to write in the drafting, he was not able to convey his case in appropriate manner at many places, and result was that reader may have to read same paragraphs twice or thrice. This is not the way how you are supposed to write your pleadings. It should be, as I said, you must know the case theory. You must know how to explain your case in one paragraph, but then when you have to write your complete pleading, you have to go into all the details. But again, when you are going in details of the case, you should not use unnecessary words. You should not use unusual words. It should be simple English, plain English, ordinary words, small sentences, as I said, small paragraphs. Sometimes you have very lengthy paragraphs, and by the time you are in middle of the paragraph, you forget what was the first line of the paragraph. That's not the way how you are supposed to write. Therefore, clarity is something which is very important, and clarity comes with clarity of thoughts, clarity of expression, clarity about the knowledge of your case. Now, second important aspect is that your writing should be concise. One thing which I forgot to tell you is that one should also be aware of how to use citations of legal authorities in your writing, particularly when you are writing journals, when you are quoting a judgment. So USA has different way of citing this legal authorities. So they invariably generally use Blue Book. In UK they use Oscola. Canada has different. Australia does it differently. But you must know in India, either you follow UK style of this or US style, depending on sometimes when you are writing. Like recently, I have just contributed a chapter on construction arbitration for a book, which is being published by Maharashtra National Law University and which is being published by Thomson Reuters. Now they said they advised me to follow Blue Book. Now it depends on what is that you are writing. Now coming back to the second quality of good writing, that is that your writing should be concise. The rationale of concise writing is that concise writing is, what is the rationale? Rationale is that it is clearer than that is not concise. It is clearer than that is not concise. It is less complex and easier to digest. And concise writing again makes the writing engaging. It is not only about being brief, but it is also about being efficient. So it's not only about being brief, but also about being efficient. Concise writing conveys the writer's points succinctly, without superfluous words and with an appropriate level of detail, which depends on the context. Using lot of words to say little is not intelligent writing. Let me repeat myself. Using lot of words to say little is not intelligent writing. Writer must eliminate all unnecessary words from sentences and all unnecessary sentences from paragraphs. So you must eliminate all unnecessary words from sentences and all unnecessary sentences from paragraphs. In fact, editing is one thing which requires proper attention. Self-editing. And sometimes if you are writing complex drafting, give some time to yourself and sit again on the same writing for editing. If you are writing something in evening, sit on that in morning to edit. It helps. It helps. And it is also important to know what is unnecessary. And what is unnecessary. In fact, it reminds me of one very interesting thing. One of the biggest lawyers of United States of America once wrote a very big letter running into 3-4 pages to one of his friends. And at the end of the letter, he said, "Hey buddy, I did not have enough time to write shorter letter or a smaller letter." That means that writing in few words requires more efforts, requires more time. it is easier to write lengthy draftings, lengthy opinions, but it is difficult to write smaller writings. For that, if you are talking about a brief for the case or a pleading for the case, then you can write in brief only when you know the case theory. You can concise your case theory in few sentences. Only then you can be brief. Otherwise, what happens is, invariably what we come across is lawyers will start writing everything what they know about the case, every legal principle which may have any bearing on the case, even remotely, everything which may be of some, even if it is not relevant, they will they'll just go on and on and on. This is not how cases are, won. You should know what is there in your favor in your case, what is not in your favor, what are the facts which are relevant facts. In fact, Indian Evidence Act talks about, in fact, before I talk about this, I must say this. Knowing in a particular set of facts, suppose client comes to you and he narrates his whole story in half an hour, 1 hour or 2 hours. Now, in order to understand what is the real controversy, what are the relevant facts, what are the relevant laws which will apply, you need either prior experience, you should have some experience, or you will have to go in a particular manner to understand the whole gamut of the facts, applicable laws, and then come to a particular conclusion about the case theory. So that is about process of legal drafting, how you do it. Suppose somebody comes to you, he comes out with a lot many facts. I wanted to purchase a property. I had done an agreement to sell with somebody. That person is now refusing to sell me that property. I want to purchase this property, but he's saying the prices have gone up. He wants me to pay something more and all and all. Now, first of all, you must know what are the relevant facts during his conversation. If he said, I entered into this agreement, but on that particular day, I was in Mumbai, I came from Indigo Airlines, I took Ola, from Ola I reached his place, there he had a Doberman at the gate, he had a guard at the gate, then I went inside, he offered me coffee, then we executed an agreement to sell. Now what is relevant is that on a particular date, he visited the house of that person and he executed the agreement to sell. Rest all are not material, not relevant. Until unless there is a dispute that he did not visit that particular person on that particular day. So one must know what are the relevant facts. Now, if you are an experienced lawyer, you would immediately say, it is a case where you have to go to court and seek a specific performance of the terms of the agreement to sell because he is refusing to comply with the requirements of the contract. But if you do not know what is that particular statute which has got relevance in this particular set of facts, that is a specific relief act, then how to deal with this? So therefore, first of all, whenever somebody comes to you, you have to do proper conferencing with that particular, conference with that particular client, note down all the relevant facts, then try to understand the applicable laws, Then try to understand the procedural laws, do proper research. Then you will get to know, try to understand relevant judgments. Then you will get to learn and know the case theory. Now, in fact, if you really want to understand the case theory, at least you should pose to yourself. One, what are the real issues involved in the case? Second, what is your position? What is your position? What is the position you have taken as a lawyer for representing your client on those issues? And third, how are you correct on your positions? Let me simplify it for you. If everybody listen to this carefully. If you are able to pose these three questions to yourself, and if you are able to answer these questions for any case for that matter, and if you are able to answer these three questions, you can write your entire case in one paragraph, howsoever complex it may be, and you will master this art of preparing case theory. First question would be, what are the real issues involved in the case? Second, what is the position of your client on these particular issues? This is 2. And 3, how are you right in your positions on these issues? So, if you go to court, what is that court asks? Court will ask you, Mr. So-and-so, Mr. So-and-so, Mr. Counsel, tell us what are the real issues involved. 2, court will ask you, judge will ask you, tell us what is your position, what do you have to say on these issues. And third, judge will ask you, tell us how are you right in your position on these 3 issues. Note down these 3 questions for yourself and try to use this and apply this whenever you have a particular set of facts being brought before you for your analysis. It will really help you, whether it is your moot competition or any other real-time dispute. That really helps. Another important thing is, whenever you have clients coming to you for conference, they come out with a lot of facts. I'm talking about complex cases. A lot of facts. You may have thousands of documents. Now, like I do a lot of construction arbitration as lawyer as well as arbitrator. Now, in construction arbitration, you will have lakhs of documents, lakhs and thousands of issues involved sometimes. Thousands is, I think, too much, but lots of issues involved, thousands of documents involved. Construction disputes are fact heavy, documents heavy, but you as a lawyer have to deal with this, and you were not at the site. You were not working at the site, but you will be representing your client before the court of law or before the arbitrator. How do you deal with this? So, very important thing is that you must prepare chronology of events, chronology of dates. This helps you. So this is the date, and generally the events are the exchange of documents or some event which can be evidenced by oral evidence. So you write all of this in sequential manner, in a proper chronological manner, so that all facts are brought at one place. Obviously, you should not write every fact. What you write is relevant fact, and that what is relevant, what is irrelevant, you get to know more and more with your experience. But this is how you should write. Another attribute of good legal writing is that it should be engaging. It should engage the reader. It should engage your audience. And Lord Denning, one of the finest judges in UK, said very beautifully about this importance of engaging the reader. And I quote, "No matter how sound your reasoning, if it is presented in a dull and turgid setting, your hearers or your readers will turn aside. They will not stop to listen. They will flick over the pages. But if presented in a lively and attractive setting, they will sit up and take notice. They will listen as if spellbound. They will read you with engrossment." So this was Lord Denning, and his writing is really famous for the way he used to write, and so you will really enjoy his writings, Lord Denning's writings. In India, we had Justice Krishna Iyer. Again, he used to write his writings used to be very ornamental and very, very interesting, very story. It used to be like a storytelling by the judges. So what does it mean? It means that your writing style should not be tedious and monotonous. It should be crisp and powerful, capable of compelling the reader to keep reading. Here you should be a good storyteller. As I said, judges do not have much of time to really go through everything. So it depends on you as a pleader, writer, that you compel him to read more and more about your case. Here there is a contrast. Contrast is, if you talk about arbitrations, in arbitrations, much depend on written advocacy. So importance of written advocacy in arbitration is something one must realize. And arbitrators will be devoting more time than the judges in reading your brief. Now imagine you have written your brief, which is being read threadbare by your arbitrator, much before you appear before him to argue your case. So before you go and argue before him, he would have gone through your brief. He would have known about the case. If you are a smart draftsman, you would have taken him along at the cost of the other side. And if other side would be a smarter draftsman, he would have taken him along. So it depends on writing style. It depends on the individuality and the personality of your writing. If you have cluttered your writing, if you are not clear in what you are saying, there is no clarity in what you want to say, then it means arbitrator or the judge will think that you have something to hide, though you may not have something to hide. So you lose the confidence of the judge or the arbitrator. If there is something which goes against your case and you have no answer to that, it is better on a particular issue, in a particular aspect, better to concede rather than timid defense of something which cannot be defended. So that shows your personality. And if you have something which goes against you, take that head on in the very beginning of your case. There's nothing which you can hide from courts. So these are the aspects which you must keep in your mind. A smooth transition from one paragraph to another paragraph. This is where you have to take the arbitrator and judges along. If you are irritating the reader, he is not going to read your brief. He doesn't have. You can't irritate. And please appreciate senior judges, the arbitrators, with their experience behind, and with the age with them, they really do not have much of patience to read your rubbish. Be concise, be precise, have clarity of thoughts, be straight, do not try to hide. Your draft should be pleasing to the eyes of the arbitrator. It should not have unnecessary words. It is pleasing. Otherwise, you are irritating. And please appreciate, judges are human beings, arbitrators are human beings. They don't like to be irritated. They don't like to be fooled. You cannot fool them. So therefore, all of this is something you must keep in mind, and which will really ultimately going to help you. Actually, for drafting, I would say, everybody should read Order 6, 7 and 8 of Civil Procedure Code. Order 6, Order 7 and Order 8 of Civil Procedure Code is something you must learn by heart. It will help you immensely. Even in arbitration, sometimes, you will hear that CPC does not apply to arbitration. Yes, Section 19 of Arbitration and Conciliation Act says CPC doesn't apply. But that doesn't mean that you should not know the basics of drafting and pleading. So even if you are interested in arbitration, I'll encourage all of you to read Order 6, Order 7 and Order 8 of CPC. That really helps. That will help you in big way. Now, one may have this question in mind that it is very good to say that write the whole case in one paragraph. But how to do that? I'll give you, as I said earlier, that first of all, understand the real facts, understand the real controversy, understand the laws applicable. Thereafter, do one mental exercise, which this is how I developed this habit. Do one mental exercise. Imagine that for that particular case, you have to appear before Supreme Court, and Supreme Court is not going to give you more than 2 minutes or 3 minutes of your 3 minutes, and you have to argue your whole case. Means you have to convey the real issues in real case theory to the Supreme Court in 2 to 3 minutes. How will you do that? Close your eyes, start thinking, start preparing sentences. Which sentence would be more powerful? Which is more preferred sentence? Which of the 3 arguments or 4 arguments would be the first argument? Do this mental exercise, knowing that you will not be granted more than 2 to 3 minutes by the Supreme Court to argue a matter. Take this pressure upon yourself. If you take this pressure upon yourself, that I have to argue my whole case within 2 to 3 minutes, you will be able to write your case theory in 1 paragraph. You may have to, if you are writing your case theory in 1 paragraph, you may have to delete 10 times, 15 times, 20 times. Don't mind doing that. Slowly you master this art, but at any level, it may take more than 1 draft. But be happy with that, be ready with that. No, it is always said that your writing should be concise, clear, and logical. Now, logic comes from a structure, and this also comes with subheads, a structure and subheads. Best way of writing is that have as many subheads as you can. If you have complex facts before you, not many facts before you, have many subheads. It makes everybody's life easier. It makes your life easier as a draftsman. It makes life easier of the reader. In fact, I have seen in many arbitrations, lawyers writing in double spacing, 14 font, size would be typeset with 14, excessive margin. Now, ultimately what happens, something which could have been written in 12 pages or 20 pages runs into 40 pages. This is not done. This is not done. Now, ultimately question would be, a good draftsman is one who understands what to write and how to write. If you understand how to write, 50% work is done. If you understand how to write, then remaining 50% work is done. Thank you very much. Thank you very much. I'm ready to take questions if you have any.
If anyone have any questions, can write in the chat box.
I see one question from Vashundhara, but where is that question? I'll have to see. Where can I see the question? Okay, here. Yes. I have a question. This is Vashundhara Kausik. Sir, hello sir, this is Vashundhara. I have a question. You shared your experience that your colleague was not able to clearly put up his case in front of the arbitrator. Can we consider that one of the Reason why a lawyer cannot express clearly, because it does mentally side with its own case and the argument that it had put. I am not able to understand your case.
That he has attorney has a bias towards his client, therefore.
Actually, there is something called predictive writing. What one should do is you should not only write when you are preparing your case, you should also try to write the case for the other side. That is another very interesting way of preparing your case. Prepare your case which you think helps your client's position, but at the same time also try to write the other side's case and other side's best case. And this prejudice the draftsman prejudice is something which is known thing, that more you sit with your client, more you read your client's document, more you prepare for your client's position, there is some amount of prejudice which is very natural. But this is where you have to train yourself to be independent. This is where you have to look at it. You have to wear two hats, one of a draftsman, another is of a oral the arguing counsel. So if you cannot argue, you can write anything what you want to write. Nobody is going to hold your hands. But when you are appearing in court, you cannot write something which is unreasonable. You cannot argue something which is unreasonable. So therefore, if you cannot argue something before the judge, you should not write that particular thing in your draft, in your pleading. So that's why I said, close your eyes, think that you have to argue before the court of law within 2, 3, 4, 5 minutes. Now, then, if you train yourself that particular manner, then you will be concise. You will be not using unnecessary words. You will not be going into unnecessary aspects. Yes. Akanksha Kumari, she says, good evening, sir. I need to ask you, as a judiciary aspirant, can you please send some light to enhance the drafting skills for a would-be judge? How one should prepare for drafting? See, this is another very interesting question. How to write a judgment is, there are many literature on that. In fact, as accredited tutor of Chartered Institute of Arbitrators UK, we train arbitrators. I train arbitrators, and I train arbitration professionals. And there we have a module on award writing. So we teach people how to write awards. So that is very similar to saying how to write judgments. So how to write judgment is something, again, this requires a whole lecture, how to write judgment. So that cannot be covered in a day in this particular session. But again, fundamental remains the same. You should have clarity. You should understand what you want to write. You should not use unnecessary words. And what happens, like in award, you give the brief of the contract between the parties. You then say what are the real disputes between the parties. What actually, I'll tell you, another way of doing it would be about how you prepare yourself for case theory. So there you say what is the real issues involved in this case, what are the positions taken by both sides, and which of the two is right. That is another way of writing a good judgment. Yes. Swati Tiwari, sir, can you please give an instance of concealment of fact which cannot be defended? Very good question, Swati. There are many judgments of Supreme Court, where it has been held that concealment of material fact amounts to fraud upon the court, and on that ground alone, cases have been dismissed. So this is a very, very important aspect. Anything which will have any bearing, material bearing on the case, should not be concealed, should not be suppressed from court. Anshula Menghani, sir, how can we find mistakes in our writing if there is no external guidance? Mistake, I don't understand what do you mean by mistake here. Mistake can be grammatical mistake, mistake can be this kind of mistake, or mistake can be of fact, mistake can be of law. So then that is why I said editing, and if it is complex writing, some bigger writing, then give some time to yourself, think over it, sit in the morning, and you will do better. Yes. Ram Subramanian, dear sir, is there any marked difference between drafting for arbitration and litigation? There is not a marked difference as such. One difference I just pointed out is that arbitrators will have more time to read your drafting. That is one. Second is, in arbitration, in particular in international arbitration, there are invariably you come across situations where parties are not granted any opportunity to make oral submissions. So whole case gets decided on written pleadings and the post trial, that is post cross examination briefs. So their written drafting is very, very important. In fact, this is typical common law way of saying that oral advocacy is everything. Oral advocacy is not everything. In fact, written advocacy is becoming more and more popular. In particular, in arbitration, written advocacy is very, very important, and you must give lot of importance. Must give a lot of importance to written advocacy. Yes. Vinita Jagtiani, good evening, sir. I would like to know your opinion on concise, clear, and structured judgments so that such judgments can be read and easily interpreted by people at large. If you want to read good judgments, the way you have narrated, that concise and properly structured judgments, read judgment of privy councils. Those days, judgments used to be very, very precise, very crisp. Read judgment of Justice Krishna here. Read judgments of, I don't want to take names of recent judges because I would be annoying some, and I don't want to go into that controversy. But read judgment of Privy Council. That is very right way of, and English judges write very concise judgments. So that is the answer. Bipasha Vishwas. Sir, I have observed that normal code can be complex from a layman's perspective. Could you please shed light on how one can segregate complex legal vocabulary and talkative legal language and not come off as too informal? See, please appreciate, you cannot afford to be too casual in your legal writing. That is one thing. Secondly, legal language, legal English is different from social English. That difference you must understand. But you should avoid legal jargons. That is what I would say. Any other question? Chetan Rangnath, respected sir, thanks a lot for the eye-opening lecture on legal drafting. I have a very simple, it may sound funny, but still I want to know what are the preferred fonts, font size, spacing, kindly let me know. See, this is a very subjective question, I would say. If you are talking about, actually what happens in courts, every court says that you should write in a particular font, in a particular font size. Like Supreme Court, they expect you to write in 14 font. Now, High Court, you should write in 12. 12 is ideal, I would say, but sometimes elderly arbitrators say, no, write in 14. Then, now the preferred font, I would say, Book Antiqua is one I like the most. I really like. Arial is again another which you can use. Spacing in arbitration, what happens in an arbitration, in the very first procedural order number 1, I especially as an arbitrator, I always write what should be the font size, what should be the font, what should be the spacing. I always say it should be 12, it should be Book Antiqua, it should be 1.5, spacing should be 1.5, it should be printed on both sides. This is how, so that I have lesser number of pages and it is environmental friendly also. Yes. Oh, Alicia Sheali. She has got interesting question. What exactly are the essentials of a good case theory? Is it okay to be biased while presenting it before the court? Sometimes people say that good drafting is also about manipulating facts. But then question is, what do you mean by manipulating? Here, manipulation does not mean that you twist the fact, you conceal the fact, and you tell lies before the court. Placement of facts in appropriate manner, in a legally permissible manner, and applying law to those facts is permissible. Obviously, there would be some biasness. You are biased. Again, even if you are not apparently, you are wanting to know, the lawyers are obliged to follow their local acts, which requires certain professional obligations from every lawyer. So professional, you cannot go in professional misconduct. So you have to be independent. You should be independent before the judge. But when you are pleading for a particular client, when you have sat with the particular client, if you have worked on a particular case for a longer number of days and days and days, then some prejudice is bound to be there. So you cannot say that you are being biased, but it will be there in some amount. Oh, so I think all questions have been answered, and this is there have been no last question. I think there have been time when the judge had criticized that the pleadings are too complex, and that at times the same judge claimed that the pleadings are written by a child. Would you say that the style of legal writing should differ from judge to judge, and their mood at the hour has a lot to do with from the writing? See, what I need to tell you is this very interesting question. There is very famous saying that a good draftman, after he writes his drafting, he should give that drafting to a first-year law student. If that first-year law student can understand that drafting properly, it means you have succeeded in your proper drafting and proper drafting skills. Thank you very much. This was the last question, and We are bang on time. It is 6 o'clock. Thank you very much.
Good evening, everyone. It's an honor for me to express my gratitude to everyone present here and making this first day of workshop successful. I, Vision Koel, on behalf of Team Nyayshastram, would like to thank Mr. Ratan Singh, sir, for accepting our invitation despite his busy schedule and enlightening all of us on the importance of legal drafting. I would also like to thank Mr. Abhishek Singh, Managing Director of Nyayashastram, for support and coordination in the planning and execution of the workshop. Mr. Aniket Datta and Mr. Deepak Thakur for getting all the required logistics in time and taking care of technicalities to ensure the smooth functioning of this workshop. I would be failing in my duty if I don't thank the team of Media and Event, Head of Promotion and Strategy, Editorial and Content team for their contribution in organizing this event. Lastly, I would like to thank all the participants who have freely participated and motivated us in conducting workshops like these. We surely hope to see you all in the next 3 days. Thank you very much and have a very great evening.